She has the right to make that request.
She doesn't have that authority because it is not within the status to her to do that, to ask for that. It is not within her authority to ask the university, hey, you cannot receive funds from this particular institution because I do not like it. She has
That's
no
a violation. Is that not First Amendment protected?
And that is a problem pertaining to your comprehension on the reading of his tweet because you have a strong derangement symptom pertaining to that matter.
Okay, so since he said a massive fraud justifies the termination of the Constitution, do you think he thinks that the 2020 election was fraudulent?
Look, I'm not going to be saying if it's fraudulent or
Non-answer. Okay, yeah, go ahead.
Quite frankly, you need to subscribe to Ringold.
I just want to preface, if there's any accusations of AI use, okay? These are my sources. They all expand down, okay? These are my sources. These are my opening statements. They're all here. They're all published. Okay, so I'm gonna preface that, say that I can show the clip before the accusation, showing all of my opening statements and things.
All right, can everybody hear me okay?
Crystal clear.
Yes.
All right.
Like water.
All right, so Rin, you get the first question. You'll have 3 minutes to respond. To what extent does the Commander-in-Chief Clause, Article 2, Section 2, authorize the President to federalize or deploy the National Guard for domestic law enforcement purposes without the explicit consent or request of state governors? If you need me to reread, I can.
Nope, I think we should be good. Just let me know when my time starts.
Go ahead.
All right. So I think that insofar as the president has power to federalize the National Guard over the governor's head, we need not look forward or further than the actual power that the president actually invoked. And the answer is that he didn't invoke any power that gives him the ability to federalize over the governor's head. Most of the legislative ability that you have to do that is through insurrection. Yep.
Oh, I'm sorry. The panel can't hear. The Section 8 can't hear. Constitution, are you teacupping?
No, I'm not teacupping.
Okay,
They can't hear him?
down there. Yeah.
Can we reset his time, please, so he can have the full time again, please?
Yeah, I'll reset it whenever we get it fixed. I don't know what. Hang on a second.
Okay.
Test. Can the chat hear?
Hey, Rita, you might need to drop and then come back up.
Okay, I will do that.
Sorry, hon.
Sorry, I didn't mean to interrupt you. I just want to make sure everybody could hear.
Okay, can everyone hear me now?
Crystal clear.
Okay.
Oh, we can hear you.
Star-Lord says he can't hear anyone except AIP and Triss. And Jade cannot hear me.
Yeah, I can hear everybody.
I can hear everybody.
We can now. Jade says she can now. I trust.
Okay,
you.
cool.
All right, I'm gonna restart your timer.
Mhm.
And well, it did not restart. Hang on.
Do you need the question again, Reynold?
No, I think I'm good.
Okay. AIP, when it's your turn, if you need the question reread, I can do that.
Okay, no problem.
All right, go ahead.
Okay, so the power that Donald Trump cited in order to be able to federalize the National Guard over the governor's head doesn't give him the ability to do that, and that's already been litigated by the courts. The power that he would actually need to invoke in order to actually do this successfully would be on the basis of national emergency that just doesn't exist, right? We went from May, when Donald Trump was praising DC's track record of bringing crime rates down by 25%, saying people have seen, they've noticed a big difference, to 3 months later claiming that crime rates are so bad that he must federalize the National Guard. We can look at Chicago, when Trump federalizes the National Guard, actually using the claim of rebellion. And when a hearing on the merits of that claim is held, it's found that based on the trial testimony, this court finds no evidence that during the approximately 2 months before the president's federalization order, protests grew out of control or involved more than isolated or sporadic instances of violent conduct that resulted in no serious injury to federal personnel, and the deputy regional director of the FPS region, responsible for protecting the Portland ICE facility, was surprised to learn that the National Guard had been called out to deploy at that ICE building. The reason that Donald Trump is federalizing the National Guard is incredibly clear. It's not crime rates. It's crime rates are a disguise for the true intention, which is just to intimidate blue cities, right? And there's no statutory authority that he's cited that actually makes a convincing argument as to him being allowed to do any of this. Any statutory authority that he would theoretically have is on the grounds of insurrection or rebellion. Those conditions just simply don't exist in the invocations that we saw in DC or in Chicago or in LA. And in a lot of cases, they don't even claim those conditions to exist. And Donald Trump just says it's based off of, this vague conception of high crime rates, even though they're coming down. And even though, his handler, Stephen Miller, comes out and says that you can never trust crime statistics from blue cities. So I don't understand how Donald Trump can say we're deploying we're federalizing the National Guard in regard to high crime rates and then claim that crime rates can't be trusted. It's very clear that the answer is he's just trying to intimidate blue cities. I'm good.
Okay. Pertaining to the question, an Article 2, Section 2, it is established very clearly that the president, it is the head of the executive, and therefore is the executive chief officer of this corporation called the United States of America. When we think beyond that part, and we go to Article 4, Section 4, it is required that every state is guaranteed a Republican form of government. And when the legislators cannot convene overall pertaining to this matter, it is the duty of the president to take action over this issue. Now, the examples that you were giving pertaining to LA, Chicago, and to Washington, D.C., there were high spikes of crime while Donald Trump was in the moment that Donald Trump was doing these ICE operatives pertaining to this matter of immigration, that we have a lot to discuss pertaining to that, because we have issues pertaining to drug lords, if you understand what I mean pertaining to that. We have issues pertaining to the what is the word I'm looking for? A lot of things happening with Islamic T groups, and the issues that are happening with Antifa, and the ambush that ICE officers are receiving on a regular basis while they are doing their operations. So it is not a nuance to try to protect the federal agents from those attacks, despite if the governors try to be cooperative or not. In fact, we have the historical precedent of 1957, President Eisenhower bypassed Governor Orfield Falvus pertaining to a matter of dispute that happened through those years. So let's not be disingenuous about it. There is a lot of things that were happening and a lot of things that were necessary for this to happen. It is not a nuance saying, the President Trump was calling the National Guard just for the sake of not calling the National Guard. He was calling the National Guard to protect ICE officers while doing their duty pertaining to human trafficking and pertaining to matters of enforcing immigration. People might not like it, but that is the truth.
Okay, Renyald, you get 1 minute.
Yeah, so I mean, I'm just going to read off this quote again because I feel like it directly goes against exactly what he said. Based on trial testimony, this court finds no credible evidence that during the approximately 2 months during the president's federalization order, protests grew out of control or involved more than isolated sporadic instances of violent conduct that resulted in no serious injury to federal personnel. You would think that if these protests got so out of control that you needed to steal the National Guard from the governors, that anybody on the ground would have actually called for the National Guard, but they didn't. The only person that made the determination that we need the National Guard is Donald Trump. And the precedent that you cited of Eisenhower reintegrating schools, that was through the Insurrection Act. Donald Trump never invoked the Insurrection Act. So the precedent that you're citing isn't comparable because it's dealing with laws that haven't been cited by the Trump administration.
Well, pertaining to that matter, there is. Sorry, are you good with that or not? Just asking.
Wait, I'm sorry.
For open discussion.
What was the question? I'm sorry.
No, I was just trying to clarify if you finish with your rebuttal of 1 minute.
Yep, I'm good.
And pertaining to that thing, the Insurrection Act has been codified through Title 10 on Section 12 406. And that is why it is initially established through the Insurrection Act that he has to give the orders through the governor. And that is why we have the antecedent of the Governor Orville Faubus to this matter, because he wasn't being cooperative over the disputes and the rallies that were happening at the time.
I mean, Donald Trump never, the precedent that he cited under Title 10 is separate from the Insurrection Act. He never declared the Insurrection Act in order to federalize the National Guard. That's just not what he did. That's why he's going on press tours right now saying, and I always have the Insurrection Act under my pocket. I can always declare insurrection. The reason he's saying that is because he hasn't done it yet, right? So this is not a power that he's invoked.
But pertaining to the court case that you were mentioning that was established by Gavin Newsom, that thing is still on lower courts. And for what I'm aware, it's going through appellate court right now. So it's not a definite statement over that matter in the court. And if it reaches to the Supreme Court will be taking into consideration Article 4, Section 4, because California hasn't been doing that much pertaining to the security of federal agents in the process of performance of immigration. Let's remember that the Supreme Court also considered that the sanctuary states are considered unconstitutional because they go against what is established in Article 1 pertaining to the capacity to homogenize the legislation pertaining to immigration and naturalization of the government. If I'm not mistaken, it should be Article 1, Section 8.
So the quotes that I'm reading are pertaining to Portland, not LA, but I cited LA as well in the opening statement. But the quote that I read out twice, that comes from Portland, right? That found that the deployment of the National Guard was in response to no call for the National Guard, no overwhelming by the state and local authorities, no call by the governor. If you're citing precedents under the Insurrection Act, it has to be applicable to other uses of the Insurrection Act. That's not what we're looking at right now. Donald Trump never declared the Insurrection Act.
He invoked the codification of the Insurrection Act. That is the issue.
But he never invoked the Insurrection Act itself, right? He never evoked insurrection.
He invoked Title 10, 12, 46.
That's separate authority.
It is not a separate authority because that is the codification for the Insurrection Act under the premises of the Insurrection Act when the National Guard should be called.
If this was the codification of the Insurrection Act, they wouldn't say that all of the orders need to be issued through the governor. The Insurrection Act, that's not what the Insurrection Act does. It's a separate thing.
When you are trying to codify a law or an act in particular, you have several sections. Therefore, this is one of the sections associated to the Insurrection Act. I'm not saying that this particular section is the only extent of the Insurrection Act. Let's be clear on that.
Sure, but in order to...
And the conditions were met, and I can quote you the particular condition that was met for that matter. The president is unable to with the regular forces to execute the laws of the United States. He was doing the enforcement of the law with ICE, and ICE agents were being ambushed on LA and in other places. That is why he had to call the National Guard for those matters.
The problem is that those forces weren't overwhelmed because nobody on the ground made a call for the National Guard.
It doesn't matter if it is not overwhelmed. The thing is that the law cannot be enforced. That is the premise of this section.
The law not being enforced means that the forces are overwhelmed, right? If the forces are overwhelmed, they can't enforce the law. That's why you need to deploy the National Guard. In this case, no lower authority made an appeal for the National Guard, and it's the same case in LA.
But the law doesn't say that.
It's exactly what it says.
The law says that you shouldn't be able to execute the laws. That's all.
Okay,
they were able.
On to question 2. AIP, this is your question.
Okay.
How should the principle of state sovereignty, as implied by the 10th Amendment, be balanced against the federal government's authority to guarantee to every state in this union a Republican form of government and protect each of them against domestic violence? Article 4, Section 4, when considering National Guard deployments, immigration enforcement, and due process.
Yeah, pertaining to this matter, I would really like to take some examples to this, because if we go by the enforcement of the immigration code and how it is being established, we have to look at the reference worldwide, and I have some notes pertaining to that. If we go, for example, to Mexico, they have been taking people out of places without no due process, and they have cases in which even sexual molestation has been established. Profiling on lack of due process and border control pertaining to Germany. It is a matter pertaining to today about this issue. And the racial profiling has to do with the Palestinians. North Korea and China, they met you with the 9mm friends. And pertaining to Poland, they are not giving medical care nor food pertaining to this matter. Canada, they are taking indefinite detentions, and they are separating families by sending the parents out of the country while holding the children. And Russia, you had ethnic profiling, and they have been displacing refugees pertaining to Ukraine and all that stuff pertaining to national security issues. And in particular, in Moldova, there is even torture pertaining to a particular inner region, which is Transnistria region within Moldova. So when we look at the enforcement of how President Trump is doing the things, he should be doing the things as it's been established by law. He's following the procedure. He's following the status and the protocols that have been established through this matter. Now we have an issue pertaining to asylum, because most of these people have been abusing the system of asylum, and they do not comply with the basic requirements for asylum. In particular, most do not comply with the third safe country clause of these exceptions pertaining to asylum. And why they do not comply? Because most of them came through the caravans that started on Colombia up. Therefore, you have several countries in which you could have claimed for asylum according to international law, and those people have no legitimate claim for asylum. And it's sad to say that, but it is the damn truth. Therefore, President Trump trying to ensure the security, calling the National Guard to protect ICE agents for doing their job and not getting ambushed, it is the logical thing to do. I'm done with that.
Reynold, you have 2 minutes.
I'm sorry.
need
That was a very Can you reread the question?
Sure. How should the principle of state sovereignty, as implied by the 10th Amendment, be balanced against the federal government's authority to guarantee to every state in this union a Republican form of government and protect each of them against domestic violence? Article 4, Section 4, when considering National Guard deployments, immigration enforcement, and due process.
Well, I mean, just as a matter of principle, we shouldn't be compromising people's due process rights like the Trump administration has, but it's my belief that in a different question, we'll litigate that further. It seems like the nature of the question is trying to get at federalism. I don't know where all of the different countries, different procedures about potentially torturing different immigrant populations, how that related back to the question. But like the general answer is that we should offer wide deference to the states because that is how our system is set up, right? We should be offering wide deference to the states. If they declare that, there's an issue and they have to, deploy their National Guard, that's their right. It's their militia. It should be an incredibly high bar for the president to come and steal that authority from the governors. It should be only reserved in times of insurrection. That's not what we exist in right now. Where we exist in right now is no ground, no law enforcement agencies on the ground, no local police precincts are appealing up for the National Guard. If they were, the governor would have deployed it. The governor never, deployed it or, gave any deference to the president. Like the conditions don't exist to where like everyone's just clamoring for like a big crackdown from the National Guard and like the governors are just derelict of their duty. This doesn't exist as it stands right now. Donald Trump is literally just coming down, stealing the National Guard from blue cities in an intimidation attempt, right? Like this isn't like genuine concern about like derelict of duty from the governors. This is just intimidation, right? If it truly was, the local law enforcement would be asking for the National Guard. They explicitly said in the hearing in regard to Portland that they were surprised to hear that the National Guard was deployed because it was unnecessary, because it was just flare-ups. There was no insurrection.
Well, are you finished? So
Yeah.
I can read you the note? Okay. Pertaining to that matter, the reason why I gave the different standards for that matter is because I knew that you will be saying the matters pertaining to the process. Because it is quite clear that these countries do not have any type of clear due process pertaining to this matter. We have a clear set of due process for these people. And it is being done through Article 2 courts pertaining to this matter. And when I mean Article 2 has been established, formed by the Article 1, Section 8 through inferior courts under Congress, but under the authority of the executive pertaining exclusively to this matter of immigration.
Yeah, the problem is that Donald Trump's administration was deporting people without giving them the ability to appeal out to Article 2 courts. That's the problem, is that through his invocation of the Alien Enemies Act, they were rounding people up, putting them on planes, and then, saying that you'll be able to talk to a lawyer and not giving them any ability to talk to a lawyer, right? So like any ability that you theoretically have through the statutes to appeal out to Article 2 courts, I agree that those exist. Donald Trump was making malicious efforts to basically buck that procedure, right? That's why they're arguing that these claims need to be brought in habeas courts, but then they also argued that you don't have to tell the lawyer where their clients are being held in order to actually file for habeas, right? These are like clear bad faith appeals to due process, but they're not actually affording them the real ability to do that.
It is not that at all, because if you look at the international standard, there is no fucking standard. And when we go to the matters of the due process, as you are claiming, the issues that it is being done through the courts. They have to just give the notice that those people should be going out of the country according to the standard that we have set.
They weren't giving them that opportunity, though.
And those, I didn't finish. And those people are being fed, those people are being well treated, and those people are being transported directly to their country of origin within a week. Not holding them for years and separating the families, as many people are saying. And pertaining to the cases, for example, the one in Guatemala, the Guatemalan woman in particular, she was asking for having her child going with her. So let's not be disingenuous about it. They are procedures being followed, and there is a lot of people trying to trample pertaining to this matter. That is why I was bringing the standard, and why we have the issue pertaining to Article 4, Section 4, which is the president has the capacity to establish the security of their people. And if those people who are coming into the country are not respecting the people, as it happened with Laken Riley, as it is happening with the Native Americans, what the fuck are we doing?
Frankly, you're just incorrect, right? Like the problem is that you're just incorrect, right? Like these people were not being afforded the ability to challenge their detention, the ability to challenge their status as an alien enemy. They were put on planes. They were detained before the proclamation of the Alien Enemies Act had even become public, and 2 planes shipped off during the hearing on the TRO on whether or not the planes should be allowed to ship off, right? So like this is a very, very clear example of people not being given the ability to challenge, right?
But habeas still has some limitations pertaining to that matter. What are the limitations of habeas? Do you know them?
The limitations of habeas?
Yes, there are limitations for habeas.
Whatever those limitations aren't applicable to these people, because the Supreme Court explicitly litigated that habeas corpus was the correct jurisdiction to bring these kind of cases.
The correct jurisdiction pertaining to those cases, according to who? A lower court or the Supreme Court?
The Supreme Court.
Because habeas is a constitutional matter. It is not something that
the Supreme Court.
The Supreme Court, in which case?
Yes. JGG versus Trump, and then later on in WMM versus Trump. Or AARP versus Trump was the Supreme Court rule. So AARP versus Trump and JGG versus Trump ruled that habeas corpus is the correct venue to bring challenges to, Alien Enemies Act cases.
Yes, but that issue cannot be disputed regardless, because you still have
absolutely can.
They still have the supreme jurisdiction over the matter pertaining to Buarfa versus Mayorkas and Sotomayor versus the United States. So,
what do you think? What claim did I just make that disagreed with?
The Supreme Court on 2024 in 2 different cases gave that authority on an 8-1 decision and a 9-0 decision. That authority fully to
what authority?
Of deporting people without the necessity of giving them a notice.
I'm so sorry. That's just absolutely not true, right? Like I could read you explicitly the ruling from JGG versus Trump saying detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. That's on page 3 of the ruling. Huh?
Entitled to notice. They are entitled to that notice. But
the Trump administration didn't provide that. That's the problem.
They cannot dispute that thing regardless, because it's not their jurisdiction to do so. And that is why they have the capacity to ask for the notice, but that's it.
All right.
Okay, gentlemen, time's up. We're moving on to the next question. AIP, this is your question. Under the Fifth Amendment's Due Process Clause, what constitutional rights, if any, must be afforded to non-citizens including those seeking asylum during expedited removal proceedings at the border or within the country's interior?
Well, since those people are coming here without any type of barring or looking who they are actually, that is a propensity for potential crime and dangers to the interiors of the United States. Therefore, pertaining to that matter, they fulfill the exception within the Fifth Amendment. And I could read that thing, except in cases arising in the land of naval forces or in the militia when in actual service in time of war or public danger. Therefore, if we do not know who these people are, and they are, for example, the issue that is happening pertaining to the Native Americans, pertaining to the HT for human transportation, if you understand what I mean with that, the smuggle of substances across the states that are unaliving a lot of Americans too. So those are public dangers that are within those people who are coming into the states. Now, are all of them? No. But a substantial portion of them, it is a potential risk for that. You might not like it, but that's basically it. I'm done.
I think he exceeded his time.
Yes.
Conceded his time. You can go for 2 minutes, Rinyal.
Okay, so I don't think that actually answered the question, right? So I'll answer it, right? So due process rights are presupposed, right? It's presupposed that you have due process rights because that's the process that's due to you, right? But what your due process rights particularly are depends on the particular type of statute that they're invoking in order to, in this case, deport you, right? So your due process rights under the INA are greater than your due process rights when you're subject to expedited removal, right? And your due process rights under the Alien Enemies Act is different than your due process rights that are allotted to you if you're being deported under standard INA procedure, right? So your due process rights is incredibly varied, right? But at the very fundamental level, it seems pretty clear that every single person who's deported should at least get some sort of ability to challenge that deportation. That's literally it. That's the only thing that most people fight for when they talk about due process is if somebody is going to be punished by the government or retributed against by the government or whatever by the government, they should have the ability to challenge that retribution from the government. That's what people refer to when they mean due process. The problem is that our statutes allow that to happen. Even people who are subject to expedited removal can seek asylum. But the Trump administration and the Republicans, time and time again, make bad faith efforts to rob people of this very, very fundamental right that you should be protecting if you're interested in the future of our republic.
Okay, the first confusion that you have pertaining to this matter has to do with the issue that these people are subject to the same due process as the American people. No, they are not. Because if we go to the preamble of the Constitution is very clear to which is the scope of the Constitution, which is the 50 states, the territory of DC, the territories associated to Washington, D.C., which are Puerto Rico, Guam, Virgin Islands, so on and so forth. And that is one thing, but the due process for immigrants is completely different to that matter. And also, you have to take into consideration that within the amendment, it is establishing an exception pertaining to national security matters because some people are a potential risk to the United States. That's why we have the right to vetting these people. And if these people are coming across the southern border without any type of vetting, giving any type of information, not telling us who they are, what is their purpose here, even why they are running away and substantiating those claims as they should according to the asylum code.
You acknowledge that, like, right as soon as I made my statement, I said that due process rights fluctuate based off of what certain type of legislation you're subject to. Like I said that right in the very beginning.
Yes, I do understand that, but the due process doesn't change because of the statute that it is being applied. The due process changes on the status of the person that is being put on trial for that matter.
So can you tell me, like, what is your working definition of due process?
A due process, according to law standards, is a process of being due.
Right.
That is basically due process. Now,
so if the statutes say that, like, if you're detained, you have the right to seek defensive asylum, like it would be a violation of the due process rights to not provide that person the ability to seek defensive asylum, correct?
But that is only at the time that they enter. If they do not enter through a proper circumstance, or even if they get rescued on the border and they are claiming asylum at the moment of getting inside the country, that could be a valid claim of asylum because you didn't go to an port of entry, because you were trying to look up for an alternative route, so you were more safe pertaining to your personal security if people were looking for you. That is a circumstance that happened. That is why we are allowing for people that is being found on the desert, on the southern border, to get their asylum claim. We are allowing that stuff.
We
The problem is
acknowledge
that most of those people are not complying with the basic requirements for that.
we acknowledge
And
it
that is
as
the
well that the INA says that you don't need to be at a port of entry in order to declare asylum, right?
That is exactly what I said. I said if they cross and they get found on the desert, they can claim their asylum claim, but they have to provide the resources and the effective information pertaining to why they were running away from that location and what is the security claim that they are making.
Okay. Yeah, I agree okay. So in that case, that would be your due process rights, right? So I guess my question is, right, when the government goes to court and explicitly concedes that the people who are subject to the Alien Enemies Act have the ability to challenge their status as an alien enemy under the Ludecky v. Watkin precedent, why didn't the Trump administration give them any meaningful ability to do that?
Because avails still have some limitations pertaining to that matter. And that is the problem that many people do not understand. Because when there is exigent circumstances, as it is happening right now, because Donald Trump, when got into office, he declared an emergency situation pertaining to the southern border, pertaining to the smuggling of substances and the human transportation.
What do you think that changes?
Address first.
What does that change?
Well, by having those exigent circumstances that put the limitations, that fulfill the requirements, should I say, pertaining to the Aliens Enemy Act. And that is why those people are being expeditiously deported through the Aliens Enemy Act.
So, no. Okay, this is just a fundamental misunderstanding.
They still have no capacity to fight it back.
That's not true. It was specifically litigated in Ludecky v. Watkins, and then again in JGG versus Trump, and then again in AAUP versus Trump, that these people have the right to notice and the ability to challenge. This is something that the Supreme Court explicitly disagrees with you on. And also the authority that Donald Trump cited to suspend entry into the southern border, by the way, which got enjoined, doesn't interact with the authority that he cited under the Alien Enemies Act. That's a different emergency statute.
Okay. The thing is that you need the emergency statute on the first place to be calling these exigent circumstances. That is the problem.
No, they're separate invocations of emergency. Those two things weren't done on the same declaration of emergency.
How did he invoke the emergency? Let's go with that.
To shut down the southern border, he invoked an emergency with people coming through.
I'm talking about the document he signed pertaining to the matter. He signed an executive order pertaining to that matter.
No, it was a presidential memorandum.
A presidential memorandum pertaining to what?
In one case, it was the shutting down of the southern border. In another case, it was the Alien Enemies Act. But they were two separate declarations.
Okay, guys, time's up. We're moving on to the next question. Rinyal, this is your question.
Yep.
How does the administration's expanded use of executive orders or proclamations to control the border and immigration policy align with or diverge from Congress's plenary power over immigration as established by the Constitution, separation of powers, and executive authority?
So I wouldn't call the authority over immigration plenary through or by Congress, because Congress does offer wide deference to the executive in times of emergency in order to, kind of process certain immigrants at different times. However, we do have credible reports. Again, I'm going to keep referring back to this case, people who have the right to appeal their designation as an alien enemy not being given that opportunity. And we also have credible claims of Congress people going to observe the conditions in which the immigrants are being kept or the migrants are being kept at the certain detention facilities that DHS holds, and the Trump administration denied them. They said you need to give 7-day notice, despite the fact that in a separate provision by Congress, they explicitly said that Congress people can't be barred from observing, from congressional observation of these detention facilities. So we see time and time again, the Trump administration, again, isn't doing this because they have some sort of principled, upholding of the law or whatever. They see see the law as like a stone in the middle of their road, right? They want to do whatever they can as unilaterally as they can, because it ultimately comes down to Trump is a bad leader and he can't dictate Congress. That's why the government's still shut down, right? He's just not a unifying leader. He can't do things through Congress. So he has to use these bullshit invocations of emergency authority in order to do literally anything, because keep in mind that Donald Trump, as soon as he came in, he said, we didn't need new legislation. We needed a new president, right? He literally explicitly says, I don't want to do anything through Congress. I just want to invoke a bunch of emergency authorities. And in most cases, they're bullshit, right? And even under these emergency authorities, he's still not providing the amount of due process that needs to be given to people who are subject to these emergency authorities, right? So I just want to make sure that everybody processes this quote from the JGG versus Donald Trump hearing or ruling from the Supreme Court. We have held that an individual subject to detention and removal under that statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether or not he or she is in fact an alien enemy 14 years or older. The detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. And then they go on to say the AEA detainees must receive notice after the date of this order that they are subject to removal under the act. The notice must be afforded within a reasonable time and in such a manner that will actually allow them to seek habeas relief. And in the hearing on this TRO, the government conceded that they should have the ability to challenge whether or not they're an alien enemy. However, they didn't provide it anyway. So they said in court, yeah, they should have the ability to challenge if they're an alien enemy 14 years or older, but we didn't give it to them. LOL. And then they said also you have to bring it in the district that they're being held, but we have no obligation to tell your lawyer where you're being held, right? So it's a very clear, very incredibly clear bad faith opportunity to prevent them from actually seeking the judicial relief that they're entitled to.
Yeah, pertaining to that matter, there is a important word that within the quote that you said, should. Should is a possibility, it is not an imposition. Let's be clear on that on legality pertaining to that matter. Second, pertaining to the issue of 7-day notice, well, they should give that notice because the agents have to establish the security background for the visits of those congressmen on the first place. They have to establish a perimeter so they do not get ambush, as many ACE agents were being done while they were doing operations. They have to ensure the safety and the conditions for those people who are also inside the facility.
So
It's
not a matter of knocking the door and saying, I want to get in, as Maxine Waters did. That is why they're asking for that 7-day period, because they have to ensure a protocol for their safety. You cannot do whatever shit you want as whatever matter. Are we in the open dialogue section, or is this his? Okay, that's what I was trying to ask. Okay.
2 minutes.
My bad. I got a little bit impulsive. My bad.
No, you're good. It's your time. Go ahead.
Oh, it is my time. So that is why the issue of GGG, it is not that relevant pertaining to this matter, because they are saying they should. It is an obligation? No. According to law? No. And I'm sorry for that. You are basing all the due process for immigration pertaining to GGG, as I'm seeing, and this matter is saying they should, but habeas corpus is not an imposition under exercise circumstances, and that is the problem. As long as there is issue with substances and trafficking, there could be a way to void that habeas corpus from origin, for that matter. That is why you have to take clear understanding of what are the limitations of habeas.
Okay, I apologize for interrupting. All right, I was literally like trying to ask if this was his time or if it was open. In those JGG versus Trump quote from SCOTUS, I didn't say should one single time. I said entitled. I said must. I said entitled and must. I literally never said should. I may have said should from my own position as a moral position that we should be affording these rights, but the Supreme Court didn't mince words. They said AEA detainees must receive notice after the date of this order that they are subject to removal under the act. The notice must be afforded within a reasonable time and in a manner that will allow them to actually seek habeas relief. They said detainees are entitled to notice and the opportunity to be heard appropriate to the nature of the case. So I never even said should, right? Or at least if I did say should, it wasn't quoting the Supreme Court. It was like a personal moral statement. But like that doesn't pertain to the legality.
Okay, my misunderstanding there. but still, there's still limitations under habeas. And if the court didn't remark those limitations within habeas, that is a little bit concerning to that matter.
So when you say there's limitations on habeas, like what are you referring to?
The limitations under habeas has to do with the issue of exercise circumstances. That has to do with a state of emergency. It has to do with potential invasions, and it's being defined by law. Hold on, I gotta go.
He's muted, right? Like we can't hear him.
Doesn't
we can't hear you, AIP.
AIP, if you're speaking, maybe mute and then unmute. We still can't hear you.
Nope.
No.
Okay. Is that a win?
Right.
I'm pretty sure he's going to come back.
Yeah,
Right.
I wasn't trying to go out. I just received a call, and that shit caught my mic. That is why I couldn't.
You're fine.
talk.
It was right about 3 minutes, so y'all go ahead.
Yeah, the matter I was talking pertaining to that issue was the matter of a national emergency, potential invasions, according how it's defined by law, among other pretty harsh circumstances. It is not a matter of just, oh, I'm going to suspend habeas for these particular cases just for the sake of suspending it. No, it is not like that.
Sure, but
That
we're
is-
not we're not subject
is
to a
why-
suspension right now.
That is why you require a prior declaration for that matter.
But
And that is why
habeas
the-
isn't suspended right now.
It is not suspended for American people.
No, it's
So
not.
matters-
It's not suspended for anybody. He never suspended habeas.
I'm not saying that he suspended habeas. I'm saying that those people asking for the habeas corpus pertaining to matters of the Aliens Enemy Act of the 1700s have suspended their habeas due to this declaration of emergency.
No, the Supreme Court explicitly said that they have the right to habeas. That's explicitly what the quotes that I just read you out.
That is why I'm saying it is concerning that the court didn't remark this matter.
You can't. He didn't suspend habeas.
I'm not saying that he suspended habeas. I'm saying that the Aliens Enemy Act doesn't consider habeas on those exercise circumstances.
It absolutely
And that is
does.
aligned with the Fifth Amendment.
No, the Alien Enemies Act doesn't preclude habeas corpus. Like it includes habeas corpus, like the way that you detain or the way that you challenge your designation as an alien enemy, 14 years or older. This is exactly what happened to the Japanese people that we interned in World War II. The way that you challenge that is through habeas corpus. That's Ludecky v. Watkins. Like the main case that litigates this was a habeas corpus petition.
But the American Japanese that were on this World War II were not being expelled out of the country. These people.
It's still an invocation of the Alien Enemies Act.
Okay, here I have the Aliens Enemy Act, immigration, enactable aliens enemies, section 2, for enacted.
Which, by the way, they afforded those Japanese people more process than we afforded the people under the Alien Enemies Act under Donald Trump, by the way. All of the...
It is irrelevant. They were not being due to process of deportation.
They absolutely are. The Supreme Court disagrees with you.
The Japanese on World War II, they were not subject to deportation. They were put in internment camps. That is why they had to challenge this matter through habeas corpus.
Correct.
That is
then it was ruled. Then it was ruled that habeas is the only route that you can challenge your detention under, and Ludecky v. Watkins was the case law.
With people being deported, you are conflating people in concentration camps with people being deported. Those are two different, separate things.
The legislation that gave the president the supposed authority to do it, what in both cases was the Alien Enemies Act, and the Supreme Court litigated that habeas corpus was the appropriate venue in both cases.
All right, moving on to the next question. Renyald, this is your question.
Yep.
Considering the Take Care Clause, Article 2, Section 3, does the president have the constitutional authority to prioritize the enforcement of certain federal laws, i.e. immigration, over others? And to what extent do these actions infringe upon Congress's legislative power?
Yeah, he has the ability to prioritize enforcing certain laws over other laws. That's absolutely true. Insofar as it doesn't contradict with any due process rights, it seems like that is an authority that the president is given. Insofar as he enforces laws, I say the president, I'm including his cabinet and everything, but yeah, like that is an authority that is given to the president. He has discretion on which laws he enforces more heavily, which laws he doesn't. There are certain justifications outlined in certain legislation that gives him the authority to invoke certain powers. Those obviously need to be taken on a case-by-case basis, but generally, which federal law he decides to enforce and which one he decides to not enforce, that's subject to presidential determination.
Well, pertaining to that matter, Article 2, Section 3 is very clear, pertaining that he has to faithfully execute the laws of the nation. That doesn't mean some laws should be more emphasized than others. It's saying all laws. Okay, let's be clear about that. And that is why he had the capacity to delegate those things to their agents. That is why he has the capacity to do the executive orders on the first place to enforce those laws. And he's clarifying in the way he's enforcing those laws.
Sure, but I mean, an example of like somebody. I'm sorry. Wait. Okay. I'm sorry. Yeah.
This is this time.
Yeah, it has to do with the matter of how it's enforcing those laws. I do understand your concern pertaining to the process of law, and I do agree if he does it without getting out of the exceptions, that could be a problem. But he has not going out of the exceptions established on Article 5 of the Bill of Rights. He hasn't, because he's taking into consideration the state of emergency that he has declared at the beginning of his term. And pertaining to all other matters, we could agree that, it is within his authority to do so. Congress has the ability to apply or create new laws, but the president has the capacity to enforce them. The judges shouldn't be considered as a matter of interpretation for the law, but a matter of making a little bit of discernment and a dispute resolution preponderant, because there is no judicial interpretation established in the Constitution. So when we have the full understanding of the powers that are being granted by the Constitution, there is a lot of part that has been taken away by the judicial, and there seems to be a judicial coup at the time by the 500 cases that are placed today against Trump. Even there is a damn tracker pertaining to those 500 cases, because everything that Trump has done pertaining to the matters of national security and how the powers should be balanced, the court has been trampling onto those capacities, even trying to supersede the capacity and the authority that the president has through the Constitution.
Okay, Rinyal, you have 1 minute to respond.
Yeah, sure. I mean, like, obviously the president, I think it's pretty self-evident that the president can enforce certain laws more heavily than other laws. That's subject to presidential authority. That's why the president currently, Donald Trump, stopped enforcing the Foreign Corrupt Practices Act. He just isn't going to heavily enforce that anymore, and it's his presidential right. That's something that he's allowed to do. I think it's always kind of silly that when a lot of Trump supporters will say that we're like subject to a judicial coup. And I feel like it's been, put on plain display here that when we make arguments of like this being a judicial coup, it's because we don't actually read any of the rulings by the judges. Right. Like if you want to like cite me a case where you think that a judge like super overstepped, then we can. Right. But it's completely feasible to me that the reason that Donald Trump keeps getting shot down by the courts is because Donald Trump breaks the law a lot. Right. Like and he's a convicted felon. We should probably expect that.
Pertaining to the tariffs, I can give you an example. The WAPO court was trying to establish jurisdiction over the tariffs, despite that Article 2 established that he has discretion to do diplomatic acts. The court was overstepping the authority of the president pertaining to the tariffs, and pertaining to the gathering of funds through the tariffs. Congress has given that power to the president under exercise circumstances again on the 1960s. So if we are going to be overstepping the authority that was given to the president, either through delegation of power or through constitutional articles, we are having a problem. And that's why I'm saying that the courts are trying to suppose a coup. That and we can see the clear contrast pertaining to that matter. We have the cases of Biden compared to the cases of Trump. We have 500 cases on 10 months of his governance. How many cases on the first 10 months of Biden did we have?
So just out of curiosity, like, could you tell me what the argument that the plaintiffs made was in the tariffs argument or in the tariffs case?
Basically, the tariffs argument is saying, oh, Congress has that authority and the president didn't have that authority according to Article 1. Therefore, that's true. But the issue is that Congress, through delegation of power established on the 1960, that the president, under particular circumstances, can exercise the power of tariffs. So
No.
Congress gave that permission to. Yes, you can verify.
So yeah,
yourself.
this is the problem. Yeah, it just reiterates, right? When we claim like judicial overstep, when we claim like weaponization, it's because we don't actually know the grounds of the case, right? Nowhere in that.
To know that the president has the authority because Congress delegated that thing on the
Nowhere
1960s.
in that legislation does it say that the president can put tariffs on.
For you to verify that information that the president got that authority.
It doesn't say tariffs.
Delegation of power by the Congress.
So I actually just came from listening to the oral arguments. The problem is that it was a question on whether or not regulating foreign foreign imports constitutes tariffs, right? That's the argument, right? And there's a real legal question there. Like, when you're regulating something, does that include tariff power? That's the question. It's not like Congress just said, hey, the president can tariff, and then the judicial came in and said, no, he can't. That's not what we're looking at here. We're looking at regulating trade. It's not even litigated that tariffs fall within that authority. That's the real question. And that's something that is subject to judicial review.
Judicial review is not a thing. It is not established in the Constitution. Give me article and section pertaining to judicial review.
Yeah, the judicial power lies in the Article 3 judges, and it's presupposed.
I'm calling the faction pertaining to judicial review. Article and section for that.
It was litigated in
Where is on the Constitution of the United States judicial review?
It's presupposed in that they outline powers of the president. Somebody needs to arbitrate those.
Where is on the Constitution judicial review? It is not.
It was litigated in Marbury v. Madison.
Marbury v. Madison was an overreach by the judicial. One of the reasons why we have on the Declaration of Independence.
By John Adams?
Hold on. On the Declaration of Independence, we had a lot of matters pertaining to the judicial, and that is why the anti-federalists were establishing the issue that they didn't want to give extreme powers to the courts.
So are you genuinely arguing to me?
Madison, the judicial power took away the power of interpretation of the Constitution.
Are you guys originalists? Are you an originalist?
I'm an originalist. That is
okay. So how are you going to argue to me that? How are you going to argue to me that a Supreme Court case written by
judicial review that thing should be constitutional? Because if we go by Norton versus Shelby County, any act that is outside the authority of any agency of the government, if it is unconstitutional, it is void ad initio.
How are you going to argue to me?
Take a breath. Take a breath, gentlemen. We're moving on to the next question. Please remember not to talk over each other so much and give each other a chance to finish your statements.
I didn't get a statement in edgewise on that one, so.
That one was pretty tough. Okay, next question. AIP, this is your question. When the president
There's a reason why
invokes
he didn't let me
statuses like
answer
the
that, by the
Insurrection
way.
Act or specific emergency powers, how should the judicial branch's Article 3 power of judicial review be applied to determine whether the circumstances warrant such a constitutional shift in power? First Amendment.
Well, pertaining to the... Oh, this is the final question, right? Just for clarity.
This is not the final question. This is your question. You have 3 minutes.
Okay, pertaining to that matter, when the president is calling the law and is invoking the law through the executive orders, he's trying to enforce those laws. That is why he's giving directions to their agents to enforce the law. And pertaining to the judicial branch, pertaining to the judicial review, it is not a power established in the Constitution. We have been butchering the Constitution through the case of Marbury versus Madison. That is why I always prefer to use the case of Norton versus Shelby County, going directly to the constitutionality pertaining to the articles, sections, and the amendments as it is being established. Because if we go by the judicial review, we should be taking into consideration that Chisholm versus Georgia, which is establishing the sovereignty of the people of the United States, it is basically pointless. There is a lot of other court cases that are more important pertaining to that matter. But still, if judicial review, it is not a power established through the courts in the Constitution. It is an overreach of power by the judicial. And that is one of the things that the Anti-Federalist and the Declaration of Independence warn us about. We shouldn't be using judicial review for that matter. And pertains to the matters and pertaining to the shift of power, we should be going to the original Constitution. When we go to the original Constitution, we establish the separation between the private and the public. They are working on the public. They are trustees for all that they are doing within the public. And their main objective through the Constitution is protect the private. That is why we have established the 10 original amendments through the Bill of Rights. 11 through 27, I could discuss extensively why they are unconstitutional, but I digress. I'm not going to be disputing that fact already.
Okay.
Are you conceding your time?
Yes.
Go ahead, Reniel.
I think it's incredibly illustrative of the current MAGA engagement with the Constitution. The fact that this is devolving into whether or not judicial review is even a sound legal practice. I think it's really silly that somebody who claims to be an originalist will see an opinion written in 1803 by John Marshall and say that it's repugnant of the Constitution. Even though he's an originalist, he's going to appeal to the founding generation, which this solely falls within. But on top of this, like, the judicial review is a necessary extension of the Constitution. It's implied throughout the entire thing. Under AIP's interpretation, every single invocation of emergency power would be unquestionable, and the president could basically just invoke emergency power for whatever the fuck he wants to, and then, it is what it is, and he could continually, invoke it, and nobody could ever question him, right? Because there's no judicial review, there's no injunctions, there's nothing there to actually stop them from doing that. This is actually a really good quote from John Marshall in Marbury v. Madison. He said, this would basically make Congress omnipotent, right? They would just say, none of the laws could ever be invalidated if Congress passed it on the grounds of constitutionality. The Congress could just pass blatantly unconstitutional laws, and no one would ever be able to strike it down. It would either devolve the entire country, because the three different branches will all have different constitutions that they're working off of that actually don't rely on any written text, or the judicial review has to exist. There needs to be an arbiter of constitutionality, and under a system with no judicial review, that just doesn't exist, right? This is the state of MAGA constitutional interpretation.
AIP, you have 1 minute to respond.
Okay, pertaining to that matter, I'm going to quote the Declaration of Independence. He has made judges dependent on his will alone for the tenure of their office and the amount of payment of their salaries. He has erected multiple of new offices and sent hither swarms of officers to harass our people and eat out their substances. So this is a clear warning from the Declaration of Independence to not give power to the judicial. That is why they didn't give the authority of judicial review within the Constitution. And within Marbury versus Madison, it is an overreach. I'm sorry. You might not like it, but it's an overreach. So pertaining to the questioning, still within my minute. Sorry. And pertaining to the question of the emergency powers, it is not the duty of the court to question those things. It is the will of the people putting the lawsuit against Trump if they consider necessary for that matter. It is not for the court to judicial review try to overthrow Trump. That is two different things.
Okay, 4 minutes for open discussion.
So if Congress passes an unconstitutional law, what happens?
Void ad initio, Norton versus Shelby County.
Wait, say again?
Norton versus Shelby County, void ad initio.
Who voids it?
The people, by ignoring
How do the people void something?
by ignoring it and acting as they do. And if they get sued because of it, you have a jury of a trial by your peers, and they have two obligations pertaining to that matter. The first one has to do with the matter of seeing if the law is constitutional or not, and the second one is
How?
the guilt plea pertaining to that matter.
How do you see if the law is constitutional or not?
Because they have to read the law that is being tried on that circumstances. The jury of peers, that is your peers.
Okay, those courts are established through Congress. Congress just passes a law saying the Judiciary Act is void. There's no more courts.
Establish that you will have to go to a jury of your peers pertaining to any judicial matter. If you go by a jury of your peers, those people have the capacity to establish if the law is constitutional or not, and they should be able to read as they are doing the trial pertaining to that matter.
So,
and the second thing that they have to establish, it is the guilty or innocent verdict pertaining to that matter. And I shouldn't be saying innocent. I should be saying non-guilty verdict for that matter.
So if Congress passes a law saying no more jury trials, what happens?
That will be an overreach. And
yeah,
that
what
will
happens?
And that will give us the authority to void this whole government as it is.
So the only way to hold people accountable for...
That is also a right given on the Declaration of Independence.
I'm sorry, the only way that you can hold an overreach accountable is by... The only way you can hold an overreach by a branch accountable is by insurrection?
Did I say insurrection?
You said that people would take arms into their own hands, right? You would try and void the government. You do that via insurrection, right?
You first have to give a proper notice to them so they have the capacity to remedy the situation. If they don't do so, that is the only circumstances that you have for that matter, because you will be on a tyrannical government. That is why we have that warning on the Declaration of Independence. Do you know your founding documents or not?
Yeah, so this is exactly why I said it, is because any system without judicial review is ultimately going to divulge into three different branches having three different constitutions, and then the country's going to collapse. And that's exactly what you're explaining. The only way, if Congress passes an unconstitutional law, the only way to do anything about it is by insurrecting the government, right? Or we could just have judicial review, which is baked into the Constitution, because obviously the founders didn't want each three branch of government to have different constitutional interpretations. There needs to be an arbiter of the Constitution, and that's what the judicial power is.
The problem is that you should not have interpretations pertaining to the Constitution. The Constitution is considered a trust contract pertaining to that matter. As any contract, there should be no ambiguity about it. That is why you cannot extract powers from the Constitution that are not there. That is usurpation.
That's why I said arbiter. You need somebody to arbitrate it, right? You need somebody to hear arguments and make determinations on the validity of those arguments. I didn't say interpret, I said arbitrate, right? So when Congress says this is constitutional, I want to pass this, they need to appeal to some third party to say whether or not it's constitutional or not.
Arbitrate is different from interpreting.
I know. When I said arbitrate, you said interpret, right? So I said arbitrate. I'm glad that you acknowledge that those two words are different.
Not you have been saying interpret all the time, and you're trying to push up the narrative
right now. We need an arbiter.
I understand what you're saying. The thing is that you're trying to imply that the arbiter has the capacity to make interpretations over the rules, and that is not the case.
No, they have the power to arbitrate.
If you go to any sport, the arbiter doesn't determine what the rules are. The rules are what they are.
Okay, moving on to the next question. AIP, this is your question. If the president uses government power, like the threat of cutting federal funding to universities or sanctioning law firms, to retaliate against organizations that have expressed unfavorable political views, is this not a direct unconstitutional violation of the First Amendment's protection against government coercion?
Okay, pertaining to this matter, I would like to quote the case of, hold on a second. Let me bring up I hate when my computer does this. There is a court case in particular which establishes certain restrictions pertaining to the First Amendment, which is Brandenburg versus Ohio. And the summary pertaining to the case has to do with that they established a certain limitations pertaining to the First Amendment, in which if I'm inciting someone to commit a crime, that could be penalized. And the second one, it is if it is likely to produce such action. Therefore, for example, if I see universities that are encouraging Palestine who are chanting constantly the issue of expand Antifada or from the river to the sea, which are calls to unalive people on a blatant way, I think that could be a reasonable action pertaining to that matter. Now, if I go say Trump is a piece of shit and he tries to take funding because people are saying Trump is a piece of shit, there we have a problem. So that is the main issue. You have to distinguish between what are the limitations within those things. If I'm going to call people to rise up and bring up armament towards other people that has no capacity to defend themselves under certain circumstances, that is problematic. That is not protected under the First Amendment. But if you are saying just critiques about the people, that is completely acceptable under the First Amendment. Now, pertaining to the fundings, the Trump seeing this characteristic has to look away to not sway, but trying to limit their capacity to go into the matters of criminality. And that is why I was bringing up the cases pertaining to Palestine, because we have several examples of institutions that, for example, Brotherhood of Islam, which is also considered a T group, that is having this issue. They are being allowed to some extent being in the United States because they are only using words, but at the moment that they have a violent rise up pertaining to ISIS or Al Jazeera or any other T group pertaining to Islamic Caliphate, we have an issue to address. And defunding those institutions for allowing or supporting those institutions, it is a mechanism to reduce their capacities.
Rignold, you have 2 minutes.
Yeah, I think it's kind of silly that somebody who just came out against judicial review cites Brandenburg as an arbiter on the First Amendment. That was established through judicial review, by the way. Yeah, Trump constantly rails against the First Amendment. He constantly says that somehow speaking against his administration is somehow engaging in illegal activity. He says, we'll probably go after people like you because you treat me so unfairly. You have a lot of hate in your heart. Maybe they'll have to go after you in response to a question regarding making hate speech illegal. He says, no talent, no ratings, 100% anti-Trump, which is probably illegal in regard to Seth Meyers. He says, I believe CNN, MSNBC, who write 97% bad about me, are political arms of the Democrat Party, and in my opinion, are corrupt and illegal. Donald Trump constantly calls political speech illegal, right? I don't know why we're explicitly or exclusively appealing out to the Palestinian protesters on campus. Donald Trump's incentives are not a mystery here, right? He explicitly says anybody who's coming out against me politically is illegal, right? He says 100% anti-Trump is illegal, right? So when he's asked a question about his own attorney general prosecuting hate speech, he says, you're so hateful and it's probably illegal and we'll go after people like you. And I reject the characterization that he gives of the pro-Palestinian protests. You can just look at the case like Ramesa Ozturk, who was exclusively had her student visa revoked due to writing an op-ed that was critical of Israel. And that is it. That's literally all. That was all that was referred to in her ROA. That was all that was referred to in her DHS referral. Literally just writing an op-ed, right? So like the idea that Donald Trump was doing this out of like the goodness of his heart for Jewish students is just not true, right? He was targeting people for their political speech. He came out and said that he wants to target people for their political speech. It's incredibly clear.
Okay, AIP, you have 1 minute.
Okay, the reason why I brought up the example of the Palestinians is because it is not an isolated example. Through this year, we had the examples that the Palestinians supporters were trying to harass Israeli people that were within the campuses across the United States. That is why we have several examples of that. And if we go prior to that, we have, for example, Mahmoud Amir Mohammed El Asa, a national of Sudan, was admitted to the United States in 2012, 11 years of prison for supporting ISIS. We have Abdurasul Hasanovich Yuvarok, Uzbekistan, admitted in the United States in 2011. He pleaded guilty in 2015 pertaining to conspiring and supporting ISIS. 15 years in prison. Abdinasir Mohamud Ibrahim, a Somalian, admitted to the United States in 2007. In 2015, he was sentenced 15 years in prison for conspiring and providing material to Al-Shabaab. Another one, Mohammed Saed Kodaimi, a national of Syria, admitted to the United States in 2001, and he was sentenced.
Okay. It's 4 minutes for open discussion now.
So, I mean, a lot of those details, I'm going to appeal again to my great Supreme Court exercising their judicial review. A lot of those are not First Amendment protected things, even for citizens, right? Providing material to support to T groups is not protected under the First Amendment, even for citizens. That's already illegal, right? So that's not a compromising of the First Amendment. That's illegal. It's illegal to provide material support to those groups already. And a lot of those charges that you listed off, you said conspiring with, or you said providing material support. That's not the same as just coming out and saying, I like this group, right? But in regard, okay, so how do you feel about the fact that Donald Trump and his administration tried to revoke the student visa of Rumeysa Ozturk because she wrote an op-ed that was critical of Israel?
Pertaining to that matter, we have signed the IHRA. And according to Article 6, Clause 2, we have to consider those treaties as the supreme law of the land. Now, do I agree pertaining to the matters of the speech in particular? No. But pertaining to her support to Palestine, pertaining to that matter, she's giving indirect support to Hamas because Hamas is controlling Palestine because that is their government. I'm sorry,
No.
you might not like it, but it's their government.
That doesn't meet the standard for material support at all, by the way.
I'm not saying material support for her in particular. But the thing is that if we go, for example, to the issue of immigration, of the manuals of this affiliation to organizations, she could be deported straight away.
Yeah, but she didn't have affiliations, and the ROA and the HSI referral or the DHS referral letter that they wrote explicitly said she had no affiliations to any group outside of it. The only thing they attached was the op-ed that she wrote asking for the president to divest from Israel. That's the only thing that they cited.
Just for clarity, are you talking about the one on Utah, or are you talking the one who went to visit the funerary service of a member of Hamas?
I'm not familiar with any of that. I'm referring exclusively what was in her ROA and her referral letter. The only thing that was attached, there was nothing outside of that op-ed.
That is why I'm asking for clarification, because there is two persons that wrote two different op-eds on two different circumstances. One went to Hamas, to Palestine, to a funerary service of a Hamas member, and the other one, because of their speech.
Yeah, I'm referring to Rumeysa Ozturk. That's who I'm referring to. She wrote an op-ed called "Try Again, President Kumar: Renewing Calls for Tufts to Adopt March 4th TCU Senate Resolutions," and that was the only thing that was attached to her ROA.
Okay, pertaining to that case, what is the relevance of her complaining to the university pertaining to their funding?
That was the reason that she got her student visa revoked. That's the relevance.
Why is she requiring from the university to drop that funding?
She has the right to make that request.
She doesn't have that authority because it is not within the status to her to ask for that. It is not within her authority to ask the university, hey, you cannot receive funds from this particular institution because I do not like it. She has
That's
no
a violation. Is that not First Amendment protected?
But the thing is that he's requiring from them to do so.
No, she's not. She just wrote an op-ed saying that he should. Are you saying that that's not First Amendment protected?
She's requesting and demanding for them to drop that fund.
No, she's not.
Okay.
Why would that give Rubio justification to revoke it? Sorry.
You're fine. I think I saw the time incorrect. You were okay to continue. But we're moving on to the final question now. Rinyal, you're going to start. Leaving aside statutory law and focusing only on the Constitution, which single action of the president presents the greatest test of our constitutional system of checks and balances? And why is your interpretation of that action necessary for the long-term health of the Republic?
I care about faithful execution of the Constitution. I think that whenever you have somebody that constantly attacks your First Amendment rights, constantly attacks people's due process rights, who explicitly came out prior to this election after trying to steal the election, after facing credible indictments for that reason, comes out and says we must terminate or that maybe we should terminate the Constitution to rerun the election that I lost. We shouldn't put somebody in a position to where they're the person executing the Constitution, right? You take an oath to uphold the Constitution, and we gave it to the person who said maybe we should terminate it. It just feels so naive to me. For every reason that I laid out, in this debate, he violates your 14th Amendment rights, your 5th Amendment rights, your First Amendment rights, and he said to terminate the Constitution. Yeah, so there's no reason to suspect that this person wants to faithfully exercise our Constitution when he says that somebody being anti-Trump is probably illegal. It's obvious to me that he's not interested in faithfully executing the Constitution. He constantly comes out against the principles that uphold our Constitution. He explicitly said, like, if we give immigrants a trial, like, we're going to spend so much time giving them trials that we can't do it. I'm sorry, Mr. President. That's what's in the Constitution. All right. You have to follow it, even if it's inconvenient to you. Like the idea that this is a person that should be trusted to faithfully execute the Constitution is pretty insane, right? It's like nominating somebody to lead a business who, hates money. Why?
Do you concede the rest of your time, Ringold?
Yep.
Do you need me to reread the final question, AIP?
Before that, I would like to fact pertaining to the quote of Donald Trump saying that he wanted to void the Constitution.
Oh, you want to fact check? AIP is.
I want to fact check that thing because on the tweet that he's mentioning doesn't.
Sure, I have it. The full quote was, "A massive fraud of this type and magnitude allows for the termination of all rules, regulation, and articles, even those found in the Constitution."
So, if we go by the quote, taking into consideration the original context, he's saying, if this is true, then this should happen. He never said that the Constitution wanted to be void. He never wanted for the Constitution to be void. He's saying, because of this, we are allowing for this to happen. And that is the problem pertaining to your comprehension on the reading of his tweet, because you have a Trump derangement syndrome pertaining to that matter. Now, can you repeat the question again, Radio, please?
Yes.
Wait, if you made an accusation against me, can I respond to it real quick?
Yes.
Okay, so since he said a massive fraud justifies the termination of the Constitution, do you think he thinks that the 2020 election was fraudulent?
Look, I'm not going to be saying if it is fraudulent or
Non-answer. Okay, yeah, go ahead. Go ahead, buddy.
No, you asked me a question. I'm going to answer that question. I'm not going to be.
Don't think you are.
Gentlemen, you will have time after AIP answers his final question to have some open discussion on this. AIP, are you ready for me to reread the question?
Yeah.
Leaving aside statutory law and focusing only on the Constitution, which single action of the president presents the greatest test of our constitutional system of checks and balances? And why is your interpretation of that action necessary for the long-term health of the republic?
Well, pertaining to that matter, I think that is not just one action. I think that it is two main actions that he has to do pertaining to this matter. The first one has to do pertaining to the vacancies of the judicial and how they should be filled, because right now we are seeing an overreach pertaining to this matter, because the judicial are trying to tell the executive how the executive should be run. That is one thing. And this has to do with how we are executing the law on the 50 states. And the other thing has to do with the nationwide incursion of Islamic groups into the United States. And I'm saying this with a little bit of concern pertaining to the First Amendment as well, because I do understand that everyone has their capacity to issue the religion on their whatever way they want it. But that exercise of their religion cannot impose a risk as is happening on several other countries. We have the examples of the UK, we have the examples of Germany, Poland, France, Italy, that they are having issues with Palestinians overall. Japan just recently shoot people out of of Japan that were Palestinians who were trying to push Islam within their country. China made it as a mental illness, just to give some references. Nobody likes Palestinians, and their issue for that has to do with the Quran, because within the Quran, it is established as their higher authority, and with their authority, it is establishing how sexual molestation should be done, pertaining to matters of unalive the infidels, who are the non-believers pertaining to this matter, and so on and so forth. Therefore, it is kind of weird. I have the quotes for that, for those things. If you want them, we can talk about the child molestation as well, pertaining to the marriage between Muhammad and Aisha, if you want to go there. So there is a lot of concerns pertaining to how Muslims are producing damage as they are practicing their religion, and the Supreme Court has established that your exercise of rights should not interfere with the peace of other people and the exercise of their rights. And Muslims, but through the Quran and through the Hadiths and through the Amims, are doing that. Right now on Minnesota, we have an issue of people being arrested for sharing Bibles. So that is a concern for me pertaining to the Muslim religion and how we should forbid it. That is my second point pertaining to this question.
Do you concede the rest of your time?
Yeah.
Okay. Host, can we have 4 minutes for open discussion on the final question?
Absolutely.
I don't know. I think it's silly to come out and say like, yeah, you know, I'm a constitutionalist, I'm an originalist, but also no freedom of religion, and you know, like the absolute cope, right, on the ending quote, like, yeah, your reading comprehension's bad because he said if there's a massive fraud, then it justifies terminating the Constitution. And we're just going to ignore the fact that he thinks that there's a massive fraud, right? Like he like that was the whole point of his 2020 re-election campaign, is that it was all going to be rigged. And then after he lost, he said it was all going to be rigged. And then he said we should terminate the Constitution to rerun the election that was rigged, right? Like it's super clear. And this is the person that we elected to faithfully execute the Constitution.
Yeah, pertaining to that matter, then why you misquoted him? If you were so empecinated on saying that he's trying to violate the Constitution, why misquoting him? That is the issue that
How did I misquote him?
That is why I have the issue with the left, because they always take a little.
How did I misquote him?
You misquoted him because it was a conditional statement. And if you
on the condition that the election was rigged, and we all know that he thinks the election was rigged.
You are not following basic propositional logic for that matter. If you have a logical statement that is,
where was all the propositional logic in the rest of this conversation?
And a conclusion, preposition, conclusion. If A happens, then B happens. That is the thing that is happening. And when you are trying to fraud something, if you go by fraud in any contract, that contract becomes void. That is the warning that Donald Trump is giving within that tweet. That is what he phrased it horribly. I do agree that he phrased it horribly, but that is the warning that he's establishing within this commentary. So you're not taking into consideration the potential, the things that were happening at the time.
Let's use some logic. So Donald Trump says a massive fraud of this type and magnitude justifies the termination of the Constitution. And when he says of this magnitude, he's referring to the magnitude that happened in 2020, right? That kind of fraud, right? So he's saying massive fraud justifies the termination of the Constitution. Massive fraud occurred. What is the conclusion that you come to after those two premises?
Okay, so you are saying that there were no issues pertaining to the...
It's a non-answer.
No, I'm asking you the question. Are you saying that 2020 had no
issues? You're answering my question with a question. I'm saying under those two premises, what's the conclusion?
The 2020 election had issues or not? Clarify that question for me before we go on into this. Because I have plenty of evidence that there were a lot of issues pertaining to the 2020 election.
I'm sure you do, buddy. You have all the evidence that all the state investigators were looking for and couldn't find, and all the courts were looking for and couldn't find, and his own attorney general and his own DOJ couldn't find. I'm sure you have that evidence. Now, on those two premises,
The Navarro report had all the edits pertaining to this matter, and I can give you some examples of judicial tampering pertaining to the Senate Bill 757.
A Senate bill has nothing to do with election fraud, but I'm saying on these two premises, right? Premises one, Donald Trump says.
I'm giving you the context because that happened on Michigan. Assembly Bill number 4.
I'm just asking what Donald Trump thinks. If you want to say that he thinks that
of Pennsylvania and pertaining to those states that were the switch states pertaining to 2020, there were a lot of ghost voters pertaining to that matter. Do you know what is a ghost voter? Do you know also the process of hammering as it is established within election procedures?
Yeah, this is TDS, by the way. I asked a very simple question. I still haven't received an answer, right? So this is the real TDS, right? We can't even attribute what Donald Trump actually thinks given these two premises that he laid out, right? This is TDS.
I have photos of USPS officers destroying ballots pertaining to those matters.
So premise one.
I have photos of hammering pertaining to the data of the election. Now, if you want, I can put it on the big screen for that matter.
All right, here's what I want you to do, okay? Premise one, Donald Trump says a massive fraud justifies the termination of the Constitution. Premise two, he says there was a massive fraud. What's the conclusion after those two premises?
I'm going to give you a chance to respond very briefly, AIP, but your time is up, gentlemen.
Yeah, pertaining to that matter, it is very simple. It was a conditional proposition. He wrote it bad, but that doesn't mean that he wanted to throw away the Constitution.
Not answer, by the way. Thank you. I appreciate you, Constitution, for setting this up. I love you, buddy.
I think everybody did a good job. AIP, I think you did very well. Reynolds, first time meeting you, but I think you did very well. Both of you held your own. Both of you came prepared, obviously, and had some decorum. I know it got, y'all were talking over each other for a minute, but that's okay. That happens in an open mic. But Radio, thank you very much. You did a great job with everything that we talked about beforehand. Korean, we didn't use you much, but when we did use you, you were there. So
yeah, I appreciate you, Korean, for reading the quote. I love you, buddy.
Hey, no problem. I try to stay very even when it comes to fact checking.
I would like to apologize for accidentally reading the next topic out loud with my question.
It's all good.
I was like, that didn't make any sense. What did that mean?
Oh Lord, it's awesome. But I mean, as far as the debate, that's it. I mean, y'all are free to stay or go. But yeah,
I mean, if everybody wants to talk about anything, I can, or I can go somewhere else. I don't know.
We might disagree on some stuff, but at least ended up in a fruitful conversation, I should say.
I have
useful is a word for it, but I mean, I appreciate you being willing to have these conversations, right? I do appreciate that.
I have some comments for you, Ren, but I actually have a debate myself on Tuesday on one of the topics, so I'm not gonna
give no spoilers.
Give you my comments. So
okay, all right. Well, I'm probably gonna drop down, but I love you guys. I appreciate you organizing it. Sorry, I talked over some of the segments. So the format's a little foreign to me, so it wasn't intentional. Trust. Yeah, I appreciate it, guys.
Yeah, well, if you ended it and then just kind of give him a clear break rather than Radio stepping in and saying, okay, now you got 2 minutes. I just rolled with the timer. So, but it is what it is. I think it was a great conversation, and y'all are welcome back anytime.
All right, thanks, buddy.
Thank you.
Conversation.
That was not a great conversation, by the way. It was actually a dookie, dog shit, horrible conversation. But